if you're in a situation where you've been charged with a DUI, or you're facing DUI charges, or your loved one is facing DUI charges, this video should help you out quite a bit. We're with David Shapiro. He is a DUI attorney in San Diego, California. He is answering some fairly common questions relating to DUI, but in addition to that, he's agreed to answer your questions directly. So if again, if your loved one is being charged, all you need to do is actually go down to the comments section at the bottom of this video, post a comment with your question, and David will get back to you typically within about 24 to 48 hours. In addition to that, obviously, if you're in a, I'll say, a more serious situation or a more time-sensitive situation, all you need to do is just reach out to him directly. He does offer free consultations, and his contact information is in the description of this video. With that said, David, I'd like to go ahead and start you in on the first question that was posted for you. If I'm convicted of a DUI, what impact will that have on my driver's license?
Well, it'll certainly have an impact on your driver's license. It will depend on how many, if any, prior DUIs you have. It will also depend on the results of your administrative per se DMV hearing. So the simplest answer to that, or the simplest question, would be someone who first-time DUI, never been convicted of a DUI before, certainly not within the last 10 years. They get their DUI, they have 10 calendar days to set up a DMV administrative per se hearing. Doesn't mean the hearing is going to be within 10 days of your arrest, but you have to request a hearing within 10 days of your arrest. And if you win the hearing, your license is good pending what, if anything, happens in criminal court. So let's say you have your DMV hearing, your attorney and his staff win that hearing, your license is good. Then if you're convicted of a DUI in court, your license will be suspended for a period of 6 months. If you lose the administrative hearing, if DMV rules against you administratively, your license will be suspended for 4 months. However, after 30 days, you would be eligible to get a restricted license, provided you do certain things. One is obtain and maintain SR22 insurance. The other is enroll in the appropriate DUI program and submit proof of enrollment to DMV. And the third is pay a $125 reissuance fee. So then you would get a restricted license on day 31. So let's say if your hearing was February the 25th, then you may get something from DMV saying that your license is now suspended. They ruled against you. Your license is suspended from March 15th for 4 months until July 15th. However, you could get a restricted license in the middle of April. So obviously, lesser included offenses like a wet reckless, a dry reckless, all those types of things would not have the guaranteed extension of a restriction or a suspension the way a DUI would. Sometimes the DUI conviction will affect your license more than other times. A lot of times, if you know and if your attorney is skilled enough to obviously be able to determine which direction the case will go at an early stage, he or she can and should be able to minimize the impact on your driving privileges. Sometimes it's as simple as making sure that if you know you're going to have to eat a suspension from an administrative perspective, with a criminal court perspective as well, DMV suspends your license after you get convicted, you want some overlap between a 4-month and a 6-month, as opposed to having a 4-month suspension, possibly you even get your license back, and then you lose it again and go back on restrictions. So there's a lot of things that could happen with your license. The simplest is with the first time. Second time, it gets a lot more complicated. You're looking at a year suspension. There's a possibility of getting a restricted license after installing an ignition interlock device. That's complicated if you're on probation for your first DUI, and so on and so forth. So there's a lot of stuff that can happen with your license. Make sure you get yourself a good attorney.
Okay. All right. The next question we have is, how does an out-of-state DUI, and I assume this is a prior out-of-state DUI, impact a DUI in San Diego?
Well, a couple of things need to be present. The first is the prosecutor needs to know about it. And if they don't know about it, then you have nothing to worry about. Assuming they do know about it, it could certainly impact, if you have any prior criminal history, whether a DUI or otherwise, but particularly something involving alcohol and driving in another state, and assuming the prosecutor knows about it, could affect the type of outcome that you're looking at as far as your attorney's ability to negotiate successfully the case on your behalf and get you the best possible outcome. As far as priorability purposes, it depends. It depends what the facts were and what the factual basis was of your conviction for that other, in that other state. What I mean by that is a lot of times it is very tempting, and prosecutors are like, oh, this person has a DWI or a driving involving alcohol from another state, and they automatically allege that as a prior DUI, which can enhance your penalty significantly here in California. But what they don't do a lot of times, and if your attorney knows what he or she is doing well enough, they can exploit them and call out the prosecutor in that regard and make it more difficult for them to prove the elements, because let's say, for an example, your prior state, whatever state that is, what you admitted is that your blood alcohol level was 0.08 or higher within 2 hours or 3 hours of driving. There are some states, I believe, that still have that requirement.
Right.
All you'd be admitting by that state would be that your blood alcohol level is 0.08 or higher within 3 hours of driving. California requires you be under the influence and or 0.08 or higher at the time of driving. So you see how there might be an issue there.
Right.
Whereas at first glance, oh, that's a prior DUI, but it's really not. If the elements of that offense wouldn't qualify as a DUI in California, you would need more than that in California. They would need to prove you were actually driving, and at the time you were driving, you were 0.08 or higher. So, it can affect it, it will affect it, but not all hope is lost just because you have a prior DUI in another state. The elements and the circumstances surrounding that conviction, ultimately we need to match up with California in order for it to count as an enhancement in California.
Yeah, well, okay, well, that makes total sense. Next question we had for you was, what types of defenses are available for high BACs?
High BACs. The best defense for a high blood alcohol content is that you weren't driving.
Okay.
I personally have won trials where the blood alcohol level was a 0.26. And, it looks amazing on the website, and everyone's like, ooh and ah. But the reality was that was a driving defense case. What I mean by that is, irrespective of your blood alcohol level, it needs to be proven beyond a reasonable doubt that you were, in fact, driving a motor vehicle. That's the first step. So if you and I were on the side of the road, say there was an accident, and the two of us may be intoxicated, if we don't corroborate or confirm with law enforcement that we were, in fact, driving that vehicle, they're going to have a hard time convicting that person of a DUI. Now, a lot of times it's easy. A lot of times you get pulled over, you're the only person in the car, it's pretty obvious you were driving. But when there's situations where you might not actually be seen behind the wheel of the vehicle, that's an element that the prosecutor needs to prove. So that's
right.
The most common. High blood alcohol level, even your theory of defense would be, hey, certainly he was 0.08 or higher at this time when that vehicle was being driven. You concede that, and I've conceded that to juries before and said, listen, this case is very simple. It's not about what the forensic toxicologist will say, alcohol, how it affects the body, what the blood alcohol level was. We don't care about that if they haven't proven to you beyond a reasonable doubt that this person or the defendant or my client was actually driving.
Right.
So that's sometimes there's issues, inherent defects within the machine. Sometimes there's issues where you have the ability to retest a blood sample, and your independent laboratory's blood sample may come back, say, at a 0.08, whereas the initial was a 0.20. It may not even be that person's blood. So that's a defense, too. Sometimes stuff gets lost, stuff gets screwed up, high blood alcohol level. Another example of how you would possibly win or get a DUI case dismissed, if not significantly reduced, even with the really high blood alcohol level, would be if there was an issue relating to the initial stop. What I mean by that is if there was no basis for you to be lawfully detained and ultimately arrested, then the goal would be your attorney would file what's known as a suppression motion, basically telling and arguing to the court that, hey, at a certain point, my client's constitutional rights were violated. Therefore, everything that was obtained from my client, blood, breath, statements, field sobriety tests, all that fun stuff, should be suppressed or kept out of evidence. So you could be a 0.30, but if there's no legal reason to pull you over, I would argue to a court that that is fruit of the poisonous tree. That's a common phrase that everyone knows, legally experienced or not. Basically saying, hey, you don't get that blood alcohol level if you make a legal stop because you wouldn't have a legal basis to pull you over in the first place.
Oh, totally understand, yeah.
So that's something. So not all hope is lost with a high blood alcohol level. It certainly depends. Driving's an issue. The reason why you were pulled over is an issue. The reason why you were arrested was an issue. You could be exponentially higher than a blood alcohol level of 0.08 or higher, but if they didn't have a reason to arrest you, there's no basis that you were driving, no basis you were 0.08 or higher at the time driving. So, this all goes to the old adage. Don't give the police anything more than what they already have. Don't do their job for them. Less is more. Don't do the field sobriety test if you don't need to. don't admit to what you drank, when you drank, where you drank it, where you're coming from, where you're going, all that good stuff. There's a reason why they ask it, and that's to convict you.
Okay, all right. Next question we had was, why should I hire a DUI attorney since so many of them plead out anyway?
Why you should hire a DUI attorney since so many of them plead out? A lot of them do. And, I represent a lot of people where we resolve cases for minimum DUI sentences, sometimes more. It depends on the facts of the case. No attorney can nor should they be able to guarantee you the outcome of the case. But some people hire attorneys, even if it's the most hopeless case in the world, just for the peace of mind to know that every stone is being turned and that everything is being done to make sure that they are going to get the best outcome possible. Some people, a lot of times, it's very difficult when you first meet a client to start talking about conviction, this, that, and the other. But a lot of times clients come around when they see the discovery, they see how your attorney's fighting for you, they see how they're explaining it to you. And sometimes it's just the peace of mind. A lot of it may be very well hand-holding. A lot of it, though, may be in situations like the previous question and my answer, where at first hope it may be lost. Oh, I'm a .17. Who's going to do anything with that? Whether I pay someone $500, whether I pay someone $5,000, who's going to do anything with that for me? Well, that's why you need the best attorney you can afford, if you can in fact afford one, so they could look at that and make sure that everything was done the right way. And if it wasn't, to call out the prosecution, to call out law enforcement before a judge on that, to ensure that your rights are protected. So just because a lot of cases play out, sometimes too, the attorney you hire can make a difference in what your sentence is.
Right.
3 people could be convicted of the same DUI, and they can have 3 different sentences, depending on how effective their attorney is as negotiating with the prosecutor, and how proactive that attorney can advise their clients on what they should be doing between the time they get arrested until that first or second court appearance. That will only help their case. So the attorney you hire, particularly on DUI cases, definitely can and many times does make a difference.
Okay. All right. And the last question we had was, will I lose my car insurance if I'm convicted of a DUI?
That is a question better directed to your car insurance. Your car insurance will definitely go up. And there's a couple of ways. If you're convicted of a DUI, and even if you're convicted of a lesser related offense of a DUI, a wet recklessly driving after consuming alcohol, or even a dry reckless, you were driving recklessly, say you pleaded down, nothing about alcohol. Those are in California 2-point offenses. You get in problems with DMV just for being a negligent operator, or DMV refers you basically politely as a bad driver, if you have 4 points in a year, 6 points in 2 years, or 8 points in 3 years. So your insurance may very well go up based on your point total. It's not something where you can go to traffic school and you get it taken care of and no one finds out about it. So irrespective of whether it's a DUI, a wet reckless, or any 2-point offense, you can have an issue based on your points.
Gotcha.
Certainly, each insurance, the reality is they could hike up your rates for pretty much any reason, and they can say you don't like it, go somewhere else. And a lot of times they do, particularly with a DUI, particularly if you're young and you get a DUI. I represent a lot of clients in their early to mid-20s who may still be on their parents' insurance and not much longer after they get arrested. Because the parents are faced with a decision: either I drop my kid from my insurance, or we all get taken out.
Right.
But it's also important to do your own research and to discuss that with your attorney. Hey, do you have any recommendations on an insurance provider that you may have worked with in the past that could help me out? Maybe I could file the SR22 insurance with a different insurance carrier to minimize the damage, to minimize the rate increases on my own insurance. So, nothing's guaranteed. It definitely will affect your insurance. I mean, that I can guarantee if they find out about it, and they probably will. But you can always do things to try and minimize the impact.
Okay. Well, for everyone watching, first of all, I want to thank you for your time. Obviously, if you have any questions, as mentioned, just post them below in the comment section. David is, as you can tell, pretty comprehensive with his answers, and will actually do the same thing for you. Also, clearly, if you're in a position where you're needing a DUI attorney rather quickly, you can just give him a call. His contact information's there, and he does do an initial free consultation. With that said, David, thank you for your time.
Thank you very much. My pleasure.